We now call 22-39417, the state of Texas versus Jacoby Damon Broussard. You, Mr. Broussard,
Yes, sir.
present with your attorney, Mr. Adams, and the state's attorney.
Yes, sir.
Earlier, you entered a plea of guilty to the first-degree felony of murder in this case. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? State
I reviewed it. I have no objections or changes, Judge.
and defense. Then without objection, it's made a part of the record for all purposes here. The agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we really are looking at no less than 5, no more than 30 years confinement in prison. I believe there aren't any other options, correct?
Correct, Judge.
Is that the way you understand it, Langston?
Yes, sir.
All right. State, want to go first and last?
I'd like to go last, Judge.
You can go first and last. You can defer. Mr. Adams, go ahead on behalf of Mr. Broussard.
Judge, if you look at page 1 of the pre-sentence investigative report, and I'm looking right above defendant's version, you'll see that it was 3 people that was all charged with murder: Jacoby Broussard, Arthur Small, Charles Moss, and they all were charged with murder. Prior to today, it's my understanding that Arthur Small and Charles Moss has already pled before your court, Judge. And Mr. Helm can correct me if I'm wrong, but I understand that Mr. Small got 8 years, and at that time, Mr. Small was already on probation in your court for another case. And then I believe Mr. Moss, and Mr. Helm can correct me if I'm wrong, I understand he ended up pleading for, I believe, 15 years, 20 years, 15 years, I believe. So what I'm asking, Judge, is if you look, and I'm only looking at page 1, when you look on page 1, Judge, you see specifically where Mr. Thomas was shot at the canal, and then he apparently had got into a fist fight, and I'm reading specifically where it says when he witnessed the fight between Thomas and Trey Moss. Trey Moss was the one who was already in your court, and I believe he took a 15-year deal. He is the one that got into the physical fight with the deceased in this case. And then apparently the deceased came back and there was gunshots. Judge, the thing that we would add to the PSI, and Mr. Helm has already provided this to my office, was the forensic post-mortem examination. And I do not believe Mr. Helm is going to contest that according to Judge, what I was going to tell you is according to the forensic exam, the deceased had a gunshot wound through the right thigh. So he took a bullet to the right thigh. And also it says it was another bullet to the left side of his abdomen. And that's in this report, Judge. Here you go, Judge. I'll just show that he was shot twice. One to the thigh and then one to his abdomen. Okay. So our position.
Here's a copy of this. Yeah.
Yeah. So our position, I can make a copy. You can have it.
Got it.
Oh, so what I'm saying, Judge, is that there were 2 shooters, and we believe to make in line with what my client said, where he said in the defendant's version of what happened.
How many times was the complainant, the victim, shot?
Well, we know he was shot twice because he was,
At least
because one was to the thigh, and that's what I'm looking at right there, and the other one was to the abdomen. So we believe that there was 2 shooters, and with the 2 shooters, and that's revealed, and there was 2 wounds, and I was letting you see where I got that from. It's our position that the wound to the abdomen came from Mr. Moss, and then apparently the wound to the thigh would have been my client, Mr. Broussard. And Judge, if you look specifically, and I'm reading.
Why do you say that?
Because
well, how can you determine that not being present?
No.
And not having any other scientific evidence to support that other than
because he was there.
Okay, it's what he's telling you.
Right, because he saw everything. He would have been there. And Judge, what I'm
So
saying
what is it you're saying his responsibility was? What did he do?
what I'm saying with there being with the victim being shot twice, I think, hey, he's a party to the offense. But what I was asking, Judge, is that when you look specifically to his criminal history, unlike Arthur Small was on probation when this happened, and he agreed to be a witness for the state to testify against my client. And then, unlike Mr. Moss, who's the one that's actually having a physical confrontation with the city, it wasn't my client. And I'm asking if you just read from the PSI, the guy who's the instigator of all of this is Mr. Moss. He's the one that's beating up the man and having a physical fight with him, and he's the one that has more incentive to shoot him than anybody because he got to fight. And our position is that you had two shooters, and that and having two shooters, my client is culpable for firing a shot, but the one who is the most culpable is Mr. Moss. And again, like I said, Mr. Ham can correct me, but I thought, if I'm not mistaken, he received 15 years. I could be wrong, it might be 20, but I know it was not 30 years. And what I'm asking the court is, Judge, is that if the man who we believe is the most culpable got 15, or I know it was no more than 20, then I don't believe my client should get the max out 30 years. And the reason I'm concerned about that is that, Judge, if you look on page 2, I see where the mother went in there said that she wanted him to get 40 to 50 years in prison, and the dad felt that he should get more than 30. But in my opinion, Judge, in arguing on behalf of my client, the person that was most culpable was Mr. Moss, and Mr. Moss did not get a 30-year sentence. And since he didn't get a 30-year sentence, it's not going to be fair for my client to get hit with 30 years when the man who was most culpable was not. And that's why I showed you, Judge, that it was at least two. There's no doubt, according to the autopsy report, it's no doubt he was hit twice. And absolutely no doubt about that. One to the thigh and one to the abdomen. And I think that my guy is responsible for the thigh, but he's not responsible for the one that went to the abdomen.
No, you've seen the pre-sentence report.
Yes,
He's not responsible for anything.
no, I didn't say that.
That's what he says here.
Okay, but
He didn't shoot anybody.
no, I hate, and I
So,
think that,
but you're saying he did shoot somebody.
I think that he needs
Is that
to
right?
clarify that. Yeah, he needs to clarify that.
Oh, he does?
Right.
Well, he was pretty clear here in that when he pleaded guilty, which was odd, but then he later admits he didn't shoot anybody. That's his inference here. But you're saying he did, even though you weren't there.
I wasn't that, Judge, but the thing is, like I said, and the reason why I brought that to your attention, just looking at the autopsy report, to suggest that there was 2 wounds, and there's no doubt about that.
I'm not surprised. I'm looking at what all this says. It appears as though 2 people did shoot. That's why 2 people apparently had pleaded guilty.
Right, and it's actually 3 people charged.
But the pre-sentence report, he's trying to play both sides. I'm guilty, but I'm really not guilty. He can't figure out which one he is, Mr. Dr. Jekyll or Mr. Hyde.
And
That's kind of a problem.
that's why I was trying to reconcile his statements with the objective
How do you
data.
reconcile he didn't shoot anybody who's pleading guilty and he wants to accept responsibility? How does that work? How does it work?
No, I think that he's going to accept responsibility for firing.
But that's not what he says here. When he had a chance, he pleaded guilty under oath, but when he went to talk to the probation office, he changed direction completely. I mean, being truthful and forthcoming is important. Do you know what happened here? A human being died. A human being, one of God's creatures. You had responsibility with that as well as the other person. But you killed somebody. You feel anything bad about that?
Yes, sir, I do.
Oh, do you? You
Yes, sir.
certainly weren't forthright here at the probation office. You want to just interrupt me?
No, sir.
That's the way you are, isn't it?
No,
I
sir.
get the feeling you like to control the situation, like you control this shooter. You seem to be the boss.
No, sir.
Well, that's the way it looks.
No, sir, you're the boss, sir.
Well, no, that's the way, and that's not the way this pre-sentence report appears. You want to play both sides. I want to make a deal, but I didn't do it. Can't have it.
Yes, sir.
I'm gonna let you talk for just a second. I want what they have to say.
You ready, Judge?
Yeah, go ahead.
Let's, let me address some of the statements by defense counsel so that we can get on the right page. Mr. Small pled to a lesser included offense of manslaughter and received 8 years TDC. That was all part and parcel of an agreement for him to testify against Mr. Broussard. He stated at the time of this incident and reaffirmed
And
during.
you feel, by the way, you feel like that is fair and appropriate under the circumstances?
Yes, sir.
Go ahead.
He's stated early on and then reaffirmed during trial preparation that Jacoby Broussard is the only person that shot Christopher Thomas on that date. There was a fourth person that was there. All this is a part of discovery. That individual's name is Ladarius, and he's Ladarius Lofton, and he's been cooperating since the incident occurred. He was one of the 4 individuals in the car, and thanks to him, he came forward whenever this body was found and told the Port Arthur Police Department about the fact that this young man was actually killed. Up until that time, they had not seen the bullet wounds in the body. The body was found in the ditch, but they mistakenly believed that it was some kind of an overdose. Had Mr. Lofton not stepped forward, we never would have gotten to the point where a murder investigation would have proceeded. He was not charged. He was present at the time, and he says again that it was Jacoby Broussard that was the shooter in this incident. So that's an uncharged individual out of this incident, and the reasons why. Arthur Small was not on probation, as defense counsel said. His agreement is based upon his cooperation. The other defendant, Charles Moss, only entered a plea after Mr. Broussard accepted responsibility. He did that on November 13th. He is waiting sentencing. His agreement was a lesser included offense of a manslaughter. Now, this all goes back to, and the whole reason why we're here talking about a cap of 30 for this individual is that factually, Mr. Adams did get one thing right. There were 2 wounds. There's nothing I can prove that there were 2 shooters. There was, we have firearms reports, and the experts were ready to come forward to show that the 2 wounds that occurred on this came from one gun, not from separate guns. So we know that fits with what the other 2 witnesses were prepared to testify, that puts a responsibility on this man for killing Christopher Thomas on that day. There's no doubt that the facts are that Mr. Moss was involved in the situation. There was a fight between Mr. Moss and Mr. Thomas prior to the incident, but there's no evidence other than this man's suggestion that Charles Moss was a shooter. And I agree with Your Honor, as you always do. You honed in on the fact that he wasn't accepting responsibility. He really hasn't done it today. His lawyer has. He stated emphatically in the PSI report that he was there, but he didn't do it, that it was Charles Moss, shifting the blame over to him. The only thing that's good about that is that him making those kind of statements led to Moss accepting responsibility afterwards, but it doesn't step away from the fact of he killed a man. He killed a man that day. He left him there in a ditch, half closed, shot in 2 different spots, and he's the one that's responsible for it. His parents are hurting. You can read that. Their wounds and their emotions just come out on the pages where you read what their responses are to this. I've dealt with this family from the very beginning of this incident when it first got indicted, and we learned that unfortunately Mr. Adams represented the decedent. before this offense occurred. This family has never been satisfied with how the system has worked in this regard. They did approve the agreement that I made, but it was very reluctant, as you can tell by their statements here. I have no doubt as I stand before the court that the man responsible for the death of Christopher Thomas is right before you. He pulled the trigger. It resulted in the 2 wounds. The 2 wounds is what caused that death. The concession to bring it down to 30, as opposed to the cold-hearted killing that it was, has a lot to do with all those facts I was just going through. There was a lot that was going to get muddy at the time of trial. There was going to be blaming on other individuals instead of accepting responsibility. I thought I had it worked out to where that was going to occur, and then we get his statements here. That being said, nothing has changed. The facts of the case, which are that Mr. Thomas was shot 2 times with the same weapon. In order for it to occur, as defense suggests, there would have had to have been some exchange between Mr. Broussard and Mr. Moss so that one shoots and then the other turns around and shoots. Is that possible? Yeah, it's possible. But it doesn't change the fact that this is the individual that 2 witnesses says killed that man and left him for dead in the ditch. 30 years is what's appropriate.
Judge, one point that Mr. Hamlin is leaving obvious is that witness, Mr. Small, has made multiple statements. When he first was approached and gave an interview, he said one thing. Then later on in the case, when the DA's office investigated him, he says another thing. My only point is that Judge Moss, as Mr. Ham stated, has entered into a plea agreement, and he's saying it's coming back for sentencing. It wasn't a 30-year cap on Mr. Moss. And what I'm saying, Judge, is by way of extrapolation and by way of deduction, when you read the first page of the PSI, it was Moss who had a physical fight with this deceased guy. It was Moss that was the one that was throwing blows with him, punching him. That was Moss. And the deceased came back. So if out of everybody there, the guy, in my opinion, that would have been the most heated, the most angry, is going to be the one who had the physical fight. And what I was trying to say, Judge, and that's why I kept pointing out about the 2 wounds, one to the leg and one to the stomach. You had 2 shooters, and that Mr. Moss is going to leave out of here with what, 15 years or something on the cap that he made for Mr. Moss. What I'm saying is that my client should not get 30 when, if you look at his criminal history, to my understanding, Judge, when you look on the last page, he doesn't have that criminal history at all. At all. He does not. And he did go to Memorial High School. He has had employment. And I think, like you said, Judge, it's best for me to, let him do more talking than me. But all I was trying to get the court to see is that there were 2 shooters based upon the wounds, one to the thigh and one to the stomach. Now, I guess the question for you today is do you accept responsibility for the wound to the leg?
Yes, sir. Take for monthly.
Yeah, they know.
And with that, he's taking. So what I want to do, Judge, is to correct and amend the PSI, because what he is saying is what I said.
Does that kill the neck? The wound to the leg?
Well, I think that when you if 2 people
Did that
shoot,
kill the man?
I
I take it from your silence, you don't have any answer to that. Yeah, well, pre-sentence report, are there any objections to the pre-sentence report?
no, I'm not going to object.
Then it's made a part of the record for all purposes. According to the authorities that investigated this case, they disagree with you.
Yes, sir.
It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. After he shot Thomas, they left the scene. And then the next morning is when the deceased's body was found in the canal, left to die.
Yes, sir.
And really, both folks who did the shooting here, the defendant and the other co-defendant, have much culpability since they acted together. The just heinous nature of just leaving this person just to die and walking off as though they had a big meal and we're going somewhere, watch a ball game or something. It just flippant. To treat a human being like that is disturbing, and to change stories through this pre-sentence report, you are not guilty, and then, but you are guilty, trying to figure a way to manipulate through this without being held responsible. But the investigators who were close to this case and investigated it believed otherwise. Both of you have pleaded guilty. Both of you are responsible for the death of this human being. And the family members are upset that even this limit of 30 years imprisonment just does not seem fair to them. The mother states he should get at least 40 to 50 years in prison. None of them called 911. None of them rendered aid to my son. And he was left there to die. And then to be found later the next day. The father of the deceased, he shot my son, made a choice to do that. He should get more than 30 years. But that is not the maximum. And he is disappointed that, as both of them, that you're not being held for more responsibility to taking their son's life, which was a tragic thing here. Anything else to add by the
No,
I was just asking too, since the other guy who was the fighter did a cap deal that was less than the 30 years, and as to my understanding, that cap was around 15 in comparability. So what I'm saying is that I would ask for my clients to be somewhere around that 15 to 20 years.
Through investigation, again, the authorities think otherwise about the responsibility of your client. It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. That's what they think from their investigation. You weren't there, I wasn't there, but the investigators put this together. He pleaded guilty. The other guy pleaded guilty. They're both responsible. Anything else?
That's your decided.
Mr. Broussard, anything else you want to add?
I apologize. I'll take full responsibility.
How do you take the life back?
Sir, I wish I can.
Do you think an apology makes a difference to that family?
I sure and I apologize to the family. It just happened. It shouldn't happen.
They don't, I guess there's not much they can do about it, but they want their child back. Can you do that?
Sure.
You shouldn't have taken it away from another human being. It's it was our creator who created it, like created you. You have no right to take it away. You understand?
Yes, sir.
You have to pay a price. You pleaded guilty in this case voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years. The judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offense. It will be rendered on the judgment. you'll be given credit for all time you have served and a direct relationship to this case. This is the sentence. This is what's fair and just. Unfortunately, I would just wish there was something in the law we could figure out how we could bring life back. But it is forever when it's taken away, and you were responsible. That is all.
Let's stay in the South. Let's go to Louisiana. Let's give the parole board a try.
Parole is now reconvening. We're at the State Police Barracks. It's Tuesday, December 2nd, 2025, and the time is 10:35 a.m. Captain, good morning. Would you introduce yourself for the record?
Yes, ma'am. Captain Patrick Washington, State Police Barracks. Who's Lisa?
Oh, Lisa Prajon with classification.
All right, you're not solo today. Good.
No,
Well,
ma'am,
thanks for having us today. And we have in front of us Mr. Is it Care?
Yes, ma'am.
Would you introduce yourself? Tell us your name and DOC number.
My name is Tory Care. My DOC number is 224-264.
And we have some folks here. Well, you can see Mr. Myers on the Zoom, also here with us in Baton Rouge. We have, your attorney, you have counsel here today. Would you introduce yourself for the record?
Yes, Grace Bronson, here for Mr. Tory Care.
Thank you. We also have Janice Bates, your mother, Sherry Jackson. She'll be speaking on your behalf. Deborah Henry, and also Quincy Bates, your father, is here. You see, we have Mr. Randall Meyer on Zoom. He's with the District Attorney's Office in Jefferson Parish. And then we have your daughter, Tori Mollison, who's also on Zoom. So your case has been assigned to me. So let me just read the information into the record. You've been through the process before, so you know how it works.
Yes, ma'am.
So you, Mr. Care, are classified as a second felony offender. You're currently serving a 40-year sentence. You were sentenced in Jefferson Parish in April 2006 for manslaughter conviction. Your parole eligibility date was February 24th of 2024, and you do have a mandatory good time release date, March 2nd, 2037. Is all that correct, sir?
Yes, ma'am.
So your case was assigned to me, so I'm going to take the lead. So first of all, we want to hear from you. What did you do to wind up in prison? I do see you had a hearing in October of 2023. You were denied because of the opposition that we'll restate today and your history of drug abuse. So what have you done since then to address those issues of concern?
Well, first and foremost, I would like to thank the board for this opportunity to be here. Again, my name is Tory Care. I'm a recovered addict. I've been incarcerated for 21 years, 10 months. I've been sober for 21 years, 10 months. I would like to say that I'm sorry to Shantae, James, Ingrid, Iron, our children, Tori, DeJaneiro, Jonquel, both sides of the family as well as the community. I admit that I was wrong. I allowed my actions, my troubled mind, to lead me to be reckless, selfish, inconsiderate, out of control. Each and every day, I think about the cause of what I've done. I regret all barriers that I caused inside their heart. God knows if I could take back what I did, I would. I'm deeply ashamed. Excuse me. I'm deeply ashamed for putting everyone through a devastating mindset, afflicting trauma, pain into their life. I pray that one day that God can forgive me for what I did. As a young kid, I grew up in poverty. The household I grew up in wasn't peaches and cream. A lot of things that I did see, I shouldn't have. And I believe it affected me the most. I started using drugs and alcohol at the age of 17, 18 years old. Not long after, I was selling drugs. I was selling, excuse me, I was selling drugs to fund my own habit. Not long after, I was out of control by the time I was 34 years of age. I used drugs and alcohol to numb all failures and responsibility, and that affected my wife and my children the most. During that time, I didn't have a clue of any resources of getting help. And if there was, the people that I hung out with wouldn't have got it. As a man, I was too prideful to admit that I had an addiction. Excuse me. And I didn't confront that as well. Instead, I allowed drugs and alcohol to consume my life to where I made all the people that I love and cherish miserable. 2024, February the 24th, I was sitting in my home on my staircase. I was smoking crack cocaine, smoking weed, drinking hard liquor, when I heard a voice outside of my window. I got up, I went to my window, I looked out, I saw my neighbor, and I saw an unidentified male standing next to her. As I went down to open my door, there was nobody to be found. At that moment, I got a little paranoid because of the life I was living. So I proceeded to go back up my staircase and continue to drink, smoke crack, more than what I was doing that night. I used drugs and alcohol all the way up to that next morning. I could recall me approaching Shantae with all my insecurities and all the rest of my baggage that I had was going on. I asked her about what was going on. She had no idea what I was talking about because when I approached Shantae, I was aggressive, I was outraged, and I just wanted answers. We went back and forth. We started arguing real heavily. I allowed myself for that argument to escalate. At that moment, I grabbed the knife. I lost control. I asked my kids to get out of the room. The argument, I escalated, continued. We went back and forth, forward and back. And that's when I heard I swung the knife at Shantae. Then I heard Tori asking for us to stop. I pushed Tori out of the way. I swung the knife at Shantae. Shantae rushed toward me to try to retrieve the knife from me. We struggled for a moment. That's when I got a strong hold with Shantae, and that's when which led me to stab Shantae multiple times. Shantae fell to the bed. I dropped the knife to my side. I realized what I have done. I know what I did. It was wrong. I grabbed Shantae. I put her on my legs and hold her on my chest. And I told her that she would be okay. Moments later, I could recall hearing the sirens. And I panicked and I laid Shantae next to the pillow. I left out the room like the coward that I was. I didn't stay to help her. I should have, but I didn't. I went to the neighbor's house where I was later arrested. and I was told that Shantae had passed away. At that moment, I knew I had a serious addiction. I knew I had to take responsibilities, to take whatever steps I had to take to change. I confessed to what I did. I gave the statement to the detective, and later I received 40 years. I had time to think about what I've done and came to understandings, which led me to put all my imperfect behind me and get some help. I've taken multiple classes as well as self-programs. I learned that any substance abuse is a complex cycle which causes problems, actions, and consequences. I had to de-escalate these problems by self-change, recognize risk, and paying attention. I also took a class, anger management, and I learned that anger management is an emotion. And to control your emotions, you have to replace old thinking patterns with the new ones. The one I got out the most was victim awareness. I learned that physical emotion, mental harm, any action caused to the victim, the family, the children, becomes a secondary impact. I had to learn empathy, learning to understand what I have done, the choices I made to cause every suffering that I proceed to do with my loved ones. All these classes, they helped me to become the man that I am today, to express what I never learned how to do as a kid, to express my feelings, to put people first, to honor and cherish my sobriety, as well as making better decisions, becoming the man that I am today. I'm seeking parole today because I know who I am now, I know who I were, and I know who I will be tomorrow. I'm no longer a liability, nor a threat to the public. I have trustworthy jobs at the training academy. I work for the state police as well as the cadets. I do interact with all different types of law enforcement throughout Louisiana. I have a great support system. My family, my children. I also have an active sponsor, a spiritual advisor. And if I'm granted, I will be going to the parole to get further assistance to help me with job training, technology, and et cetera things. I also took another program that will help me with the same curriculums. It's called FOM Fathers on a Mission. I'm here today asking the parole to give me a second chance, have mercy, to where I could finish my sentence on parole. I want to prove to the parole board, my children, my family, the community, that I can be an excess achiever in society. Again, I would like to say that I'm sorry. James, Aaron, Ingrid, Tori, Dejanero, Janquel, both sides of my families, as well as the community. Thank you.
All right, I'll have some questions for you in a little while. Captain, what can you tell us about Mr. Kerr?
Good morning again, you all. Tori's been here for 3.5 years. In that time, he's done an excellent job working for us. He currently works, as he said, at the Training Academy, and he's around all of the employees at the State Police Academy, and we have nothing but positive things to say about his work ethic.
Thank you, sir. So we'll hear from the folks that want to speak on your behalf. Could we first hear from Mr. Myers with the Parole Project?
Yes, good morning. Kerry Myers with Louisiana Parole Project. We were here for Tory at his last hearing. We continue to be here for Tory. One of the things I think that you is evident is his remorse is genuine. And I think that reflects everything about Tory. He's genuine. He understands that his addictions led to his actions, and he has continuously taken steps to address that particular issue, his addictions. He's committed to his sobriety. He's committed in the future. He's been committed while he's incarcerated to his sobriety. Parole Project will help him through his transition. We will obviously take him into transitional housing. We'll provide him with support systems, a case manager, and mentorship. We'll help him with technology and financial matters. He'll also be evaluated by our social workers, and particularly with his addiction issues. While we believe he is actually, I think his plan already is pretty comprehensive about his sobriety, about having a sponsor. We'll continue to evaluate that and work with him in that. The maturity he's shown at the age he is now, we think he's an excellent candidate. I think his character comes through in his sincerity. We believe that Tory is an excellent candidate for parole, and we just ask this board to grant us parole today.
All right, thank you. So here we have Ms. Sherry Jackson. Could we hear from you now?
Good morning, members of the board. My name is Sherry Jackson, I'm Tory Care's sister. I work for a nonprofit organization, just got Church Diocese of New Orleans. I've been there for 34 years. Married. My husband is in law enforcement also in the Young Police Department. He's been on this job for 37 years. We have 3 kids. My oldest, which is my niece, and my godchild, who I raised with my husband since she was 22 months old. She has a 7-year-old child. My oldest son, he has a 13-year-old grandson. And my daughter is expecting her first child back in England with her husband. First, I want to begin by acknowledging the immense pain and loss that Shantae's family and loved ones have endured. There are no words that can take back the tragedy or the loss that my brother has endured. My family holds them in our thoughts and prayers every single day. Over the years, I've seen my brother truly accept responsibility for what he did. He has shown genuine remorse, not just through words, but through actions. He has participated in the ministry, self-esteem, think for change. He's in the work release program. He's received his forklift and GED certificate. He knows his consequences of his actions, and he's working hard to become a better person. I'm not here to excuse what he did. I believe in responsibilities, I believe in change, and I believe in redemption. And every person can learn from their worst choices. Granted parole, our family will continue to support him with his rehabilitation and reintegration into society. Thank you for allowing me to speak, and thank you for considering this case.
Thank you. We appreciate your remark. And so we have Mr. Bates Senior.
Yes. Good morning.
Good morning.
My name is Clinton Bates. I am Tory father. Me and Janice have been married for 51 years, me and my wife. When Total was born, I went to the hospital and picked him up in 1969. He have always been, and trust me, obedient child. What happened to him, it take God to tell me. I never would have thought where I raised my child. He's a good child. He's a good man that did a bad thing, a shameful thing. And he come around to his actions. He know what he did. And I told him it was shameful and it was wrong. My grandchildren suffered just like me and my wife and his sisters. We have suffered for 20-something years. I haven't had a decent night's sleep since my son been incarcerated. He's a good man. I told him I wasn't going to sugarcoat nothing for him, and I won't lie for him. And he know that. At one time, when I was working, he got out of school. I had a job for TCF Construction Company. I built a bridge, I-310, from north to south. Every deck I built for TCF Construction Company. I had to have 15 minutes. One of them was Tory. He was a smart, no attitude, wasn't afraid to get his hands dirty or his feet. I brought him out there, him and his brother. He made it. My other son didn't. I had to let him go because he couldn't do the work. Tory's a good man, trust me. If you let him out of here, give him a second chance. Ever who hired him, are a good man. A man that would work. I done tested it. I worked it. When I went to farmers meeting, when I went to classes, went on the job to check the job out for what I was doing with 15 men and my son, he was my lead man. When I walked off the job, he took control. Supervising men, 50 older than me. He's a good man. He's a hard worker. And who hired him, if y'all cut him loose, he would make a good employee and a good neighbor. What he did here does not reflect the way I raised my children, my daughters, and my grandchildren. I love every one of them. I got over 15, 20 grandchildren. And I know every one of them. I love them, I help them. What Tory did was shameful. I love my grandkids. And guess what? They love me too. Before all of this happened, they would come by my house on the weekend, go in my backyard, I grow plants. And Tory liked to grow plants, which is good. He would take some of my plants. I wouldn't tell him nothing. He'd walk out there with him, you know what I'm saying? Go home, set his house up. Every now and then I would go there. I felt like I'm responsible for certain things that happened in his life because I wasn't there enough. Even though I took him fishing, I took him hunting, I got him jobs when they got grown, I cleaned them when they was babies. I did all of the things that a father and a grandfather could do, and I'm proud of him. I did not desert him. I gave him a chance. And he held remorse. When he grabbed me and hugged me, when I first talked to him after I went and seen him in Bogalusa, he squeezed me so tight, and he was crying and shaking, and so was I. I'm 50 years old, I'm 51 years old, I made 51 years old last month. And I told him that I want to live long enough to see him free again. I think he paid his due. That's not my decision to make. I don't know. That's up to you, gentlemen, ladies and gentlemen. But I tell you this here, you won't make a bad choice. I supervised 15 men. I dealt with men my age and old and young. I respect people. I come from a respectable family. We don't believe in hate, knocking other people. Tory's like that too. He just did a bad thing. He took after me. I respect people. If David Duke was in here, I respect him too. I ain't got nothing to do with what he do or how you think.
Thank you, Mr. Bates. We appreciate your testimony.
If he was here, I would respect him. If I had to work for David Duke, I'd give him the same thing I give myself for my mama.
Yes, sir.
I don't care nothing how you feel about it. It's about respect.
I agree. Thank you, sir.
Yes.
It's not about rank.
We're gonna move on
I
now.
raised my kids like that, people. And I did every one of them.
We're gonna move on now, sir. Thank you. We appreciate it.
I'm good?
Yes, sir.
Thank you very much.
Thank you,
Thank you.
sir. All right, Ms. Bronson, could we hear from you?
Good morning
Morning.
to you all. Good to see you all. Thank you all for being here and continuing to hear all of these cases day in and day out. It's not an easy job, and I feel like I say that when I come before you all, balancing a lot of different factors. We are before you, and I have the pleasure of representing Mr. Care, and have been working with him for the last couple of years, and have been talking with him and understanding the depths of what led him to this situation. And I think that we all know in doing this work, but also understanding the complexities of people, that they come into and arrive at these instances where a crime is committed and harm is done, but not in one instance. Mr. Care, despite having a really supportive family, as you heard from his father, had a strict father, had a father that demanded work and demanded that he be better than him, and all of that came with him and from his past. That translates into different ways, different cycles of control or abuse or violence that then are brought up and are seen. Mr. Care has mentioned those things that he has had to figure out for himself, to what led him to killing a woman that he loved. And I say that he loved her to honor her, to bring Miss Shante into this space. I know his daughter is watching. He has multiple other children that he has relationships with. And this we have to honor her. We have to bring her into this space, and I don't take that lightly. And I know Mr. Cares doesn't, or his family, who all had a relationship with her as well. Over the past 21 plus years, Mr. Cares has devoted himself to doing the only thing that he can do. If he had the power to bring Shante back, I know that he would. The only thing that he can do is put his time in to be a different man, and to find out why he did those things. He's taken all of the required DOC courses that he was eligible for. He's taken and some. He's participated in and got certifications, his GD, all of the basics that I'm sure are reflected in the paperwork that you all have. And since his last hearing, he took what the board had to say very seriously. He's continued to work at the police barracks and gain trust. As you heard, he went from working at the Office of Motor Vehicles to now working at the training facility with the Louisiana State Police, with the cadets, and people who are in training, as well as the other officers and troopers there. He has taken Thinking for a Change, Cage Your Rage, and continued to go deeper into his sobriety plan and developing a plan by getting a sponsor, having an active AA&A schedule that is rigorous, as well as facilitating a 12-week program. All of those certificates should be before you all as well. His reentry plan is extensive, not just his family support and the parole project, but also he has employment opportunities. He has the ability to continue to get counseling, to get sobriety, to have his sobriety plan and be engaged in that for a lifetime. And I will say that in terms of being incarcerated for 21 years, he has 10 write-ups. He has been interviewed and chosen to be at the police barracks, which he has been for a couple more years since he was last before you all. And so I would say that all of that creates Mr. Care to be a kind man. He's an honest man. I've sat and listened to him and talked to him for hours about what his decision and what he did. And I know and stand before you all today, not just as his attorney, but as somebody that has come to know him, that he is deeply affected by this and knows that any chance moving forward would only be to pay a debt that he can never make up. And he is fully aware of that, and also wants to continue to grow in himself, but also give back and talk to young people, and coming from New Orleans, where his family is, where there's a lot of need for that. And I would say that there are a lot of opportunities and communities for support for him there as well. So as always, any questions that you all have for me, but thank you all for taking this opportunity and listening. So thank you.
Thank you. Any questions? Thank you. All right, so now we'll hear from the DA's office, Mr. Meyer.
Good morning, Randall Meyer, Assistant DA, Jefferson Parish. First off, I'd like to make a correction in that misstatements, I guess, from my letter in opposition. The annual assessment stated that he still needed 12 steps, but I did then found in the progress report that he has completed 12 steps and some other substance abuse programs. And then looking at some of the other certificates, I don't know how I missed that, and I apologize for that, but there's been quite a bit of substance abuse participation that he's been doing since the last hearing. The captain spoke very well of him, of things that he's done. However, because of the nature of the offense, his criminal history, and only serving 21 of the 40-year sentence, we'll maintain an opposition to his request at this time. If this board does decide that parole is in order, we would ask that part of the conditions of parole would be that he continue with AA treatments. Thank you.
Yeah. All right, so I have some questions of you. So, Tori.
Yeah.
So or remarks. I do appreciate the work you've put in since your last hearing. I think you've done applied yourself to address the concerns that were mentioned to you. When we first got started, I think I heard you say, as you introduced yourself, I'm a recovered addict. Did I hear you?
Ma'am. Yes, ma'am.
And then I heard you say something, I think, about your AA participation, that you realize that it's ongoing.
Yes, ma'am. That's a part of me, and that will be a part of for the rest of my life. Like I say, I honor and I cherish my sobriety, and I take that real serious, because without that, I wouldn't be the man that I am today.
Right. So I say all that to say, I think maybe it's more appropriate that you refer to yourself as recovering, because you'll always be recovering.
Yes, ma'am.
Never get over it. You got to work at it every day.
Every day.
The rest of your life.
Yes, ma'am.
So tell me a little bit more about, one of the things I noted after your last hearing was there was some concern that you don't accept full responsibility for what you did. It seemed, and I wasn't on that panel, but it seemed at that time that you did lay some blame on the victim. Address that concern for me.
Yes, I have laid the blame on Shantae. I know that the 15 years that we were together, at that moment, I felt betrayed, and I knew I was wrong to feel that way, because Shantae was a good woman. She was a hardworking woman. Shantae never drank, go out, party. She never did none of that. Shantae was really the backbone holding our family together when I couldn't. I was so far gone, I didn't even realize it. And I came to an understanding that I put all my insecurities on Shantae to blame her for all my wrongdoing that I have done. And today, I regret that, because I am to blame. I was the aggressive one. I was the one that caused everything that happened. And I am the reason why we're here today.
Okay. So let me ask you this. One other question, and then I'm going to defer to my colleagues, because I think I understand what your plan is and all of that, should you be successful. You mentioned earlier that you saw some things as a child probably should have never saw. Did you say that?
Yes, I did, ma'am.
So as I understand it, when all this happened, your 12-year-old daughter was a witness.
Yes, ma'am.
And she actually tried to get between the two of you to stop you.
Tori,
How do you think she feels about it? What do you think that did to her even today? Have you thought about it?
Yes, ma'am. she, right now today, was just like me, traumatized for what she saw me and her mother go through. And that's unacceptable. What I say today to the board, it don't justify what I did. I know I put my daughter through a lot of harm, aggravation, and every day my daughter have to live with it. She have to live with she have to live with that. And if I can undo that and give a hard closure, I would do anything to do that for Tori. Tori deserves the best. Tori is a smart young lady. She always have. And I should have never have put Tori nor her mother through that. And I regret it up to this day. Every day I have to live with that the rest of my life.
As does she.
As does Tori.
All right, I have no other questions. I'll defer to my colleagues. Mr. Prater?
I don't have any questions. Do you have any contact with your other children?
Yes, yes, I do. I talked to my son, T. Ryan Brown. I talked to DeJaneiro. I talked to my son Tyron. I do send word to the ones who I can't locate to. And I also talked to my son Jonquel. Yes, sir, I do.
Okay. I don't see any other questions, Tori, so I think we're prepared to vote, and I'll be voting first. Well, you know, I reviewed very carefully the entire record that was presented to us. I looked at real hard at what you've done since your last denial. Listen to what the captain said, and I think that the parole project is a good program that has put together a really good transition plan. I'm impressed by the fact that you've set up your sponsor and you realize that you got to do that for the rest of your life. I'm willing to take a chance and grant you parole today to that plan, long-term plan. And do the requirement of AA meetings every week, at least twice a week. At least twice, more would be preferable, because you can help others in those meetings too.
Thank you. I will. I promise.
I'm just one vote. That's my vote. Mr. Prater?
I concur with that. I lean heavily on what the captain has to say. And so I concur with what you.
Mr. Freeman?
Okay, I was that vote she was talking about last time that I didn't think you had accepted responsibility, but today you have fully changed, and I really do believe you have accepted responsibility for what you have done. So my vote today is also going to be to grant, but I do not want you contacting Tori. If she wants to talk with you, she is to initiate it. Okay? Do not initiate or bother her unless she wants to.
Yes, sir.
You understand?
Yes, ma'am.
Up to you.
I'd like to say one more thing. I would like to say Merry Christmas. Thank you.
Let's go back up to Michigan, where justice is best served in a converted pole barn. This is Judge Mertz.
James Dick on behalf of Mr. Whitmer, Your Honor.
Mr. Whitmer, did you have an adequate opportunity to go through the pre-sentence report with your attorney?
Yes, Your Honor.
Okay. Mr. Dick, are there any additions, deletions, or corrections to that report?
Your Honor, yes, there are a couple corrections that it should be noted. Three 284, Your Honor, page 6, under family. Mr. Whitmer's sister, Jennifer LaBeouf, she resides in Philadelphia, not in Michigan.
Okay. Any objection to that change, Mr. Rowland?
No, thank you.
And under marriage, Jessica Sinandi, she lives in Tennessee, not Michigan.
Any objection to that change?
Not at all, thank you.
The last, there's a couple more, my apologies. The employment narrative, the third sentence, he receives Social Security. He does not currently receive any Social Security that's been terminated.
Any objection to that change?
No, Judge.
Okay.
The next page, Your Honor, CFJ 284, page 7, substance use and treatment. The methamphetamine, it was listed as unknown, the start date. It should reflect 2008 as the start date to present.
Any objection to that, Mr. Rowland?
Judge, I have no information to counter that information.
Okay.
And then lastly, the substance abuse treatment. The inpatient at Gaudenzia, the end date was 36 days after the January 1st entry date.
Okay, so February 5th? That sound right?
Yes, sir. Right. Yes.
All right, we'll indicate an end date of February 5th. Okay.
No other additions, deletions, or corrections, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor. Find them acceptable and accurate.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
I do not, but I thought the defense also had an additional document from Mr. Whitner. I
Yes.
advised to court.
Not yet.
Okay.
But no objection to court proceeding.
Mr. Dick, when you go back, can you move that podium that way?
Yes,
I
right.
can't see Mr. Rolla. Thank you. There we go. Perfect.
But other than that, just no additional additions or deletions.
All right, Mr. Rolla, do you have any challenges to the scoring of the guidelines?
No, Judge.
Anything on behalf of the people for elocution today?
Yes, please. Thank you. This is the defendant's first felony. However, as is made very clear from the PSI, the defendant traveled all the way from Pennsylvania to Michigan to commit this offense. And unfortunately, the reality of the circumstances, as I understand it, and as indicated in both the police report and the PSI, the defendant is one of many individuals, many of them homeless, that an organization was using multi-state to commit these same type of offenses, not just in Michigan, in many counties, but in other states as well. There's a guideline, a guideline of 0 to 6 up to 5 years with a recommendation of 6 months with 93 days credit. The situation that we were advised of this morning is that the defense is asking for placement in a Lions Den facility. And again, that may be fine. However, the problem that people have with that is it's not a lockdown facility. The people's concern is that the same type of situation that arose to have Mr. Whitmer come all the way from Pennsylvania would still exist, and effectively, because the individuals that are using these people, like Mr. Whitmer, as pawns to do their effectively illegal other crimes, just pick them up all over the place and then take them and commit crimes elsewhere. I don't think that that's an appropriate circumstance. I think at a minimum, even though it's a first felony, there should be some verification that we know where Mr. Whitmer is, because even his own family didn't know where he was because he was a homeless individual. So that's a concern of the people. Thank you.
Mr. Dick?
Yes, Your Honor. So as Mr. Ellis stated, Mr. Whitmer was used as a pawn in this matter. However, he takes responsibility for his actions of walking in and actually doing what he admitted to do. The history that he has, most of it is all substance abuse related, and that played a factor in him doing what was done during this particular incident. Mr. Whitmer, as it reflects in the PSI, he's not had contact with his children or his wife, who he's separated from for approximately 9 years, because he finds some sort of shame in his substance abuse. And he noted when discussing this with the probation officer that he intended to contact them once he was clean. Now, when this PSI was written, the original tentative date of sentencing would have given him 93 days of credit. I believe that is now roughly under 20. So if he were to serve the additional time, even for the 6 months, I believe he would have around a month left of his time in custody. Mr. Whitmer has made affirmative efforts to reach out and be accepted to the Lion's Den because he wants to change his life. He knows that he could just sit in jail and do these additional 30 days or whatever it might be, and then perhaps walk away if the court was to adopt the recommendation. But that's not what he wants. He would like to commit to the 8 to 10 month program at the Lion's Den to take advantage of the support that they offer, the guidance that they offer, and to help him establish a new life. He's looking for a clean start after this incident a clean start in general once he is completed at the Lion's Den. If the court would be willing, I think it would be reasonable to allow him to attend the Lion's Den as a rehab facility, although he is dried out from his substance abuse after being in custody at the jail for the period he has been. It will help with his reprogramming. It will give him guidance, and he does find hope in God. So with that being said, Your Honor, the Lion's Den does report right away if somebody were to leave their facility. Mr. Whitmer, he admittedly has nowhere to go. He's lived in homeless shelters and whatnot for many years, and he hopes to establish some sort of a life and home for himself. And he has expressed to me that he likes Michigan. And it gets him away from what he was dealing with back in Pennsylvania. With that being said, Your Honor, we would ask that the court permits or extends him perhaps probationary period to allow him to show that he is actually trying to change his life. And court would have the reporting from the Lion's Den should any of his circumstances change. That being said, I don't have anything further.
Thank you. Mr. Whitmer, did you have anything you wanted to say today?
I just want to say, I just want to apologize to the court. Sorry, I was in church time at the time. I'm working on my substance abuse, and I've been clean for about 4 months, and I'm feeling great. You know, getting in contact with God. I never done the church services. You know, I feel very, I'm very, very good about myself. So I want to share.
All right, Mr. Whitmer, I did review the report, so I'm familiar with your background, your circumstances generally, as well as what happened in this particular case. This crime is concerning from our community standpoint, and we have folks coming in from other areas of Michigan or different states specifically to victimize our community. As a court, I have an interest in punishing and deterring that kind of conduct.
Yes.
And so I think a jail sentence is appropriate. You know, based on your record and what happened, I don't think probation is necessarily an unreasonable option, but given your lack of any ties to this community, any individuals that are local that could vouch for you and say, hey, we're going to keep an eye on him and make sure he's doing what he's supposed to do, then I think maybe it would be more appropriate. But in your case, I don't think probation is something that's going to be helpful to the community or to you, frankly. I do think the Lions Den is a great program. A lot of people from my court here, and particularly in Crawford County, participate in that program. They do an excellent job. But Mr. Roll is exactly right, and that's the first thing I thought of when I saw this, which is they don't force you to stay there. So I could let you out. You could go there tomorrow, and Friday you could decide you want to go back to Pennsylvania. And yeah, they'll let me know that you left, but that doesn't do us any good because you're gone. And based on your lack of any ties to the community, based on anybody here local being able to say, yeah, we're going to keep an eye on him, we're going to make sure he stays there and completes this program. I don't have any, and based on what happened in this case, I don't have any confidence that if I were to release you early or have you go there, that you would actually complete that program. And the fact of the matter is, once you've served your jail term, if you really want to do that, you can go right there if you want to.
Yeah, sure.
So I think the recommendation is appropriate. I think it's fair. I think it provides for a degree of punishment and deterrence so that other folks know if they're going to come here to try and commit these kind of crimes, that there's going to be a penalty to pay for that. The court is going to sentence you to 6 months in the Otsego County Jail. I did calculate that credit because this was set for sentencing on November 5th. So I come up with 120 days. Did you?
121, actually, Judge.
121, okay, 121 days. So 6 months of credit for 121 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, the DNA testing fee of $60 and a $68 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Dick, have you provided the appellate rights to Mr.
Yes, Your Honor.
You can have him. Mr. Whitman, you're amended request to the count.
All right, the court is calling 2025 CR 013212, State versus Joe Anthony Garcia. Could I have parties approach and announce for the record? All right. And are you Joe Anthony Garcia?
Yes, ma'am.
All right. You entered into a plea on November 18th. Both parties agreed to waive PSI and the TAP evaluation. According to your plea bargaining agreement, punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your applications. All right, defense, do you have any witnesses?
No, Your Honor, only allocution.
All right. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
John Anthony Garcia.
All right, defense, you may proceed.
What prompted you to burglarize that house?
I needed to shower. So it's my stepmother's, my father lived there with my stepmother. So he said anytime I needed to go shower, you just go there. And when my stepdad, or my dad, Joe Garcia, he had left, got arrested by the U.S. Marshals. She kind of started acting different, like changing up in her mood and telling me I couldn't be able to go there. And then one day, the next day, she would tell me I was able to go there. She gave me food and stuff like that. At the time, I was homeless. I seek the Haven for Hope, which I still am seeking now to this day, and it's been kind of, but it was kind of hard. So I went back one last time to see if I could shower inside and get some food and get some rest, because I like to be outside a lot. And she wasn't there, so I kept knocking on the door. Went to the window, the side of the door, knocked on that side, and kept going back and forth. I went back the last time to the door, and the door was propped open. So I was like, "Huh, okay." So I went inside, me thinking it was unlocked for me. So I went inside, and I went to go take a shower, and after that, I went back. I left out. But
Well, any other questions?
Were you intoxicated at the time?
No, sir.
Did you have a job at the time?
Yes, sir, I did. I worked at Wren Hill Staffing.
If she gives you deferred adjudication, can you go back there for your job?
Yes, sir, I can.
Are you sorry for what you did?
I'm very sorry. I'm really not a bad person. I really do stay out of trouble. I do respect everybody. You know, it was just at that time I was going through a moment with my dad and my stepmother. But I really differently did learn my lesson. Being incarcerated as long as I've ever been locked up, and I really don't like it. It's not for me.
Nothing further, Your Honor.
All right. So let me just tell you what the summary says. It says that the front door to the home or to the residence, because I don't know if this is an apartment or not, had been damaged because the U.S. Marshals raided the apartment. So I'm assuming the U.S. Marshals kicked in the doors and nobody ever repaired the door. So she states, while she was asleep, you entered the residence and stole property from the location. So it's not that you entered the residence and took a shower, it's you entered the residence and stole property. And she received notification that someone was trying to use her stolen credit cards. So, you want to speak to that?
Yes, ma'am. I'll speak to that.
Yes, please do.
Yes, I did take the credit cards.
Why?
Because I was hungry.
Was your name on the credit card?
No, ma'am, it wasn't.
So did anybody give you permission to take a credit card?
No, ma'am.
So this wasn't you just coming in to take a shower and leave. This was you coming in and you knew that, according to your testimony, you knew that the U.S. Marshals had already raided that apartment.
No, ma'am, I did not know that.
So when did you discover that the U.S. Marshals had raided?
I found out when I saw it on her notepad saying finally the U.S. Marshals came and got my dad.
All right. And so there was a notepad in the home?
Yes, ma'am.
So that means that, again, you were not just in that apartment to take a shower. You were in that apartment looking around for things. And what it says on here is, Mr. Garcia, because he is the son of Miss Tobias' ex-significant other. So that part of your testimony is true. She stated that she had video surveillance that shows you moving the camera so it wouldn't catch you taking property. It's odd that in here there's no listing of you taking a shower, because it says that when you entered this apartment, she was asleep. I don't know how big this apartment is where people don't know someone else is in their location with them. But she said that she was asleep. No mention of you ever taking a shower in any of these police reports. Did you ever give a statement to the police stating that you had taken a shower?
No, ma'am.
So there's nothing in here about this shower business. The only thing that's in here is that you came into that apartment and it was easy for you to come into the apartment because the US Marshals, I'm assuming, kicked in the door, damaged the frame, and the door was sort of propped. So that part of your testimony is true. It's sort of propped open. But you went in and you were moving surveillance cameras around and taking things that did not belong to you. Discuss.
The property was in her room. I went to go knock on her door. She was my stepmother and my dad. My dad has a history of doing heroin. All right, he's a drug. So my stepmother is the same way. I went in her room. She goes,
Oh, you're saying she's a heroin user?
she is. I'm not gonna lie. I'm not gonna sit here and lie on camera either.
But she has a place to stay
She does.
and she has credit cards.
She does because of my dad.
Okay.
She does because of my dad. And I went to go knock on the door. She was knocked out. I was, just tapping on her shoulder and everything. And she was still knocked out on the bed. No response. And I saw another dude in my dad's bed with her. So it kind of, that's why I did everything I did right there at that moment. So it kind of threw me off.
So now you're saying that when you came into the apartment after having knocked on doors, you go in, you see her in the bed, you tap her on her shoulder to try to wake her up, and then you notice there's a man in bed with her. Did you tap him on his shoulder as well?
Yes, ma'am, I did.
So-
I knew both of them.
Oh, so you tap him on his shoulder.
He gave me a response. He said the door is unlocked for me.
Oh, this story keeps
Well,
keep adding to the story. So when you tapped him on the shoulder, he says the door's unlocked for you.
yes, ma'am. That's how I got it in there, took a shower.
Oh, and who is this person?
I don't know his name like that.
But you said you know him.
It's his street name,
Oh, what's his street name?
Joker.
Joker. Okay. Continue, please.
So I went to go take a shower, and then I get out the shower and I go in the room and so I'm leaving. Then after that I left.
All right. Well, any other questions?
Oh, Your Honor.
Well, according to your plea bargain agreement, the state is silent, but the state always reserves the right to address any issues that may be untruthful. So state, any questions?
I was gonna find the exact about Judge, but there's no mention in his original allocution of the credit cards. And that he said he was staying out of trouble, or he tends to stay out of trouble, but he does have the criminal history beyond just this.
All right. And what is the criminal history?
No, Your Honor, she's supposed to stay silent. That's not.
No, part of the PSI and TAP evaluation, I always say that anybody can bring whatever witnesses they want to bring. And one of the things I would need would be criminal history. But if you all want, I can reset it for a PSI and TAP evaluation to obtain that.
No, Your Honor, you're going to find out one way or the other.
All right. What is the criminal history? And please, only the convictions. And counsel, if you want to review what they have with regards to criminal history.
No, Your Honor.
Okay. Oh, well, defense, would you like to tell me or?
No, Your Honor.
Okay.
Has a theft conviction 100 to 750 from August 25th of 2022. The terroristic threat conviction from January 16th of 2025. And that's
Oh, okay. And has anyone spoken to the complainant?
we did make efforts to reach out to her, Your Honor. We were unsuccessful.
Okay. All right. That tells me a little something. So how often have you been using? And you need to be honest with me.
Marijuana.
Everything. Don't just come to me with, I only use marijuana.
Marijuana I've been using, well, for about 5 years.
All right. And other drugs?
Meth I've been using about just 1 year when I met this girl.
And when did you start using meth? You say 1 year.
Last year.
And how old are you?
28.
And why did you start using meth? last year?
I met her in the streets.
Who did you meet in the streets?
My girlfriend. It's a girl that I met, but we're not together no more.
And what are all the tattoos with the numbers about?
This is my birth year, 1997. This,
And that's what?
a little money bag.
hmm
And this is money, power, and weed.
Money, power, and weed.
Yeah.
All right. Have you ever?
I got these when I was young.
All right. Thank you. All right. State, you may be excused. Have you ever had any mental health diagnosis?
No more.
And where's your mom?
My mother, I was in foster care, but my mother, I never got to meet my real mother. My stepmother, Joanne Pearson, she's on 4006, 4006.
No, I don't need the address or anything. But I'm just trying to figure out what has happened in your life that you're now before me, having now addicted to meth, using marijuana on a daily basis, going to this apartment where your stepmother is, and your father, I'm assuming, is in federal custody.
I've been alone all my life, like that. I got out of CPS at 17 years old, and after that, it's been.
And did you even try to sign up for college? You know they give that to you for free when you're in the foster system.
I did sign up for college, but I didn't get to go.
Well, here's the thing. When you're in foster care, depending on when you did that, you still may be entitled to free college. You need to look into that. And sometimes people don't want to go to college, that's fine. But they have extended it to where you can get your trade certification in something, all right? All right, here's the thing. I'm going to give you a choice today. And these are your only choices. Don't ask me for anything else. And if you want to speak to your attorney about what would be the best decision possibly for you to make, you can do that. The state is asking for a cap of 8 years. I'm taking into consideration all of your testimony. I will sentence you either to 3 years in the prison, or I will give you your application for deferred adjudication. If I grant your application for deferred adjudication, and if you're unsuccessful, you're looking at potentially 20 years in the prison. Do you understand?
Yes, ma'am.
Do you wish to speak to your attorney?
I will take the deferred.
All right. Ms. Abrams, are you ready?
Yes, ma'am.
All right. The court will sentence you to 6 years deferred adjudication.
Yes, ma'am. I'll let you down.
All right. There's a $2,000 fine that will be probated. There's to be a TAP evaluation in custody. Follow recommendations. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. Field visits 1 time per month until further notice. And the proof of employment will be 45 days within release of custody. There's to be no contact with Janelle, Janelle Tobias. There's to be 300 hours of community service restitution. One hour will be deducted for every sober support meeting completed. I'm going to order 60 sober meetings in 60 days. And you're either going to obtain a trade school certification in something to better yourself, or either you're going to college. You understand? So either a trade school certification or enrollment in college. I want you to be able to have some kind of means of supporting yourself. And maybe the best way for you is to get your trade certification. What I can tell you, sometimes people will look at criminal history and it doesn't go well with you finding employment. One certification, though, that people always need, believe it or not, they always need welders. So that would probably be a good profession for you. But again, find whatever your passion is and follow it. You understand?
Yes, ma'am.
As long as it's legal. All right, probation, is there anything else that's needed? Is there anything else you need from the court in order to be successful?
No.
All right, and probation, could you see about helping him with housing? And I would do just hold in abeyance the referral to felony drug court. I know their graduation is not coming up for a while and they don't have any room, but if you could always just have that there for him. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, here you go. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. From here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for 20 years? If it is, don't do it. If it's, it could be, don't do it. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back to court. If you are out and about and you feel the stresses of life are getting to you and you think you're going to use, don't use. Contact your sponsor. If you can't contact your sponsor, call your probation officer. Trust me, if you call your probation officer and say, I'm thinking about using, what's going to end up happening is they're going to let me know. I'm going to have you brought into court and we're going to see what programs or what we can do to help you. But do not disappear and do not just say, oh, I started using, so therefore I'm not doing anything anymore. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank
And
you.
don't do any more the tattoos, money, power, and weed. That's not a good tattoo. Okay.
All right. Thank you.
You're welcome.
Thank you, Judge.
Thank you. And
Yeah.
Ms. Abrams, can you also see if there's any trauma issues with him? All right. Thank you.
Money, power, and weed. One of those things is not like the other.
Let's change it up. We'll go down to Florida. Say good morning to Wade Mercer.
Cause for these 7 charges. Let me tell you what these charges are, Mr. Gunsby. Trafficking in methamphetamine is the most serious charge. That's a first-degree felony with it's either carries a maximum 30 years or life in prison, one or the other. I'm not positive. It's a first-degree felony. I am sure about that. Possession with intent to distribute cocaine is a second-degree felony. Possession of firearm by convicted felon is a second-degree felony. Possession of ammunition by convicted felon is a second-degree felony. Sale of methamphetamine is a second-degree felony. And then you have a third-degree felony, unlawful use of a two-way communication device. And lastly, a misdemeanor of possession of drug paraphernalia. I'm going to listen to the attorneys, Mr. Gunsby. I have looked at your criminal history, and I'll listen to the attorneys before I address your bond status. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Just that he'd be subject to random UAs, and only is a convicted felon, so he can't possess a firearm, but no possession of firearms.
Mr. Gunsby, I'm going to set your trafficking meth bond at $50,000. The second-degree felonies will be $25,000 each. So, Corporal, that would be the possession with intent to distribute cocaine, possession of firearm by convicted felon, and possession of ammunition by convicted felon, $25,000 each. The sale of methamphetamine also is a second-degree. No, actually, that's a second-degree felony, so that'd be $25,000. The third-degree felony, unlawful use of a two-way communication device, would be $5,000, and the misdemeanor would be $2,500. That's the paraphernalia. So when you add those together, you get a total of $157,500. Is that what you got? $157,500. You do have a condition of random urinalysis, Mr. Gunsby, from starting today. Mr. Gunsby, I know that's a high bond, but you've got some very serious charges. You've also Got some criminal history there. I think you may have been in prison, I think twice. Is that right, Mr. Gunsby? I know it's been years ago, but is it twice?
It's been once, and I haven't been in trouble in the last almost 20 years.
Yeah, but you accused of trafficking meth, and allegedly, they do a controlled buy on you. The confidential informant says there's a substantial amount of meth in your home. They get me to review a search warrant. I determine there's probable cause. I sign it. Then allegedly they go to your home, serve the search warrant, and find exactly what they were told would be there. So that's the basis for the charges. So, Mr. Gunsby, you'll get a chance to use the phone in just a few minutes to try to post the bond. You don't need to talk about the charges. If you have questions, I'll try to answer them, but don't talk about what you're accused of. Do you have any questions?
Yes, I do.
Okay.
The residence that's
about the charge.
He said.
I'm also going to ask the jail to give you a notice for your court date. That would be January 6th at 8:30. I did.
He did.
Can you text one of the ladies to see if YouTube's working or not?
It is.
It is? Because in one place it says it's not, one place it says it is. Any other questions, Mr. Gunsby? I think we froze again, didn't we?
Yep.
Yes, Mercy.
I step away for one moment just to make an emergency cookie run and get these lovely Pepperidge Farm Milano lemon white chocolate cookies. And he freezes. But the good news is we're in the Wayback Machine here a little bit. So let me see if we can bump him forward a little past his freezing issue. There we go. All right, let's continue with Judge.
Yes, sir.
Yes.
Great. Mr. Gore, you're here because you have an out-of-county warrant out of Calhoun County. Mr. Gore, I took a look at that warrant this morning. It appears to have a cash bond of $803. $803 cash bond, Mr. Gore, and you will get a chance to use the phone after first appearance. If you post the bond, you'll be released. If you don't post it, you'll be transported to Calhoun County either today or possibly the first of the week. When you get to Calhoun County, you go to another first appearance there. Do you have any questions, Mr. Gore? Good luck to you, man. Have a good day, sir. Alexander Williams.
Ashley, thank you, by the way. 2 gifted memberships. Very much appreciated.
Morning, Mr. Williams. You're here because you've been accused of 1 count of felony battery by strangulation and 1 count of misdemeanor battery, Mr. Williams. It looks to me like there's a warrant out of Gaston County. Now, it's a little confusing. It wouldn't let me pull up the warrant, but it shows a warrant on a 2019 Gaston County misdemeanor case, 19-177. But again, I couldn't actually see the warrant. Their computer system shows an active warrant. So I'm going to tell you there may or may not be an active warrant. I'm going to ask the jail to try to verify that after first appearance. So be aware of that, and they'll let you know what Gaston County tells them after first appearance. But in the Jackson County case, I think you're entitled to a bond as far as I can tell. Let me see if the attorneys have any additional information before I address that. Mr. McDaniel?
No, Your Honor.
Mr. Mitchell?
Nothing for the state, Your Honor.
So, Mr. Williams, in the Jackson County felony battery by strangulation, your bond's going to be $5,000. The misdemeanor bond will be $2,500. Your total bond is $7,500 cash or surety. That means you can go through a bondsman if you wish. That's what a surety bond is. Mr. Williams, you do have a condition of no contact with the alleged victim, and you will get to use the phone shortly. But Mr. Williams, I'm going to ask them to try to find out from Gaston County if there's a warrant or not before you use the phone. That way you'll know that, and your family will know that, whether there's 2 bonds out there or just the Jackson County one. I'm also going to ask the jail to give you a notice for your court date in Jackson County on this felony charge, which is January 6th at 8:30. Do you have any questions, Mr. Williams?
No, sir.
Have a good day, sir.
Okay.
Michaela Scott. Ms. Scott, good morning. Ms. Scott, you're here for first appearance, ma'am. You've been accused of 1 count of reckless driving. Ms. Scott, there is probable cause for the charge. I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I've talked with Ms. Scott. She's going to plead no contest. The charge is listed. Understanding she'll be placed on probation for 6 months. Be a $483 fine. She'll take a driver improvement class while she's on probation. And withhold adjudication, she has signed her plea waiver form waiving the right to a jury trial and call witnesses.
6 months probation. How much was the court costs and fines, Mr. McDaniel?
483.
473 is what our clerk's office is saying. You okay with that?
That's fine. I guess I can get the 483 because that's what's on my page for, that we was given years ago, but it could be wrong.
I have no idea. We don't see this charge that often. Usually if we have a reckless, it's with alcohol, but this is without alcohol. So Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Scott, did you hear that agreement?
Yes, sir.
I know you've got an issue in Holmes County, and you'll deal with that issue at a later date. We don't really know. It's just a little confusing. You're on a PTI over there for some kind of driving offense, but it's there's no conditional release. There's no probation as far as I can tell. It looks like just a regular PTI. So you're probably going to have to go to court over there, and we'll see what they do. Whatever y'all work out over there. But in the Jackson County case, is this a plea you would like to enter, ma'am?
Yes, sir.
Ms. Scott, I'm going to accept your plea of no contest to the charge of reckless driving and withhold adjudication of guilt, ma'am. Sentence you to 6 months probation. Court costs and fines of $473, ma'am. Possible early termination of probation, which means you may be able to get off in 3 months if you get everything done successfully. Mr. Mitchell, I may not have asked you, is this agreeable with the state?
It is, Your Honor.
Thank you. So, Ms. Scott, what's going to happen, ma'am, is next is they're going to let you use the phone. Then they're going to let you get dressed in your regular clothes, and then they're going to bring you to the courthouse to meet with the probation officer. You'll meet with one of our probation officers, ma'am, and then you'll be free to go. If you do call friends or family, tell them that you can be picked up in roughly 30 to 45 minutes at the Jackson County Courthouse. Ms. Scott, do you have any questions?
No, sir.
All right. Thank you, ma'am. Have a good day.
All right, thank you.
Yes, ma'am. And then we have the add-on case, and that was Mr. Harry Cole. Mr. Cole, good morning. Mr. Cole, I'm trying to pull your case up now. You weren't on the list, but my understanding, all I've been told is that your family has been calling and asking the clerk's office what's going on because the weekend judge wanted your case reviewed today. So we're just trying to do what the weekend judge asked to do. Mr. McDaniel.
The weekend
you know anything
judge
about
told me that. Okay.
He's not asking a question.
Mr. McDaniel, Mr. Cole, give us just a second, Mr. Cole. We're going to try to figure out. I can watch the video. It may be quicker to see what the jail knows or Mr. McDaniel. You know anything about it, Mr. McDaniel?
Yeah, Your Honor, it's a child support issue, $1,200 and $1,000 purge on 2 cases. Bay County's on the way to get him. I would have thought they'd have got him by now, but when did they say they're coming?
And I don't have a date, so.
Don't have a date?
That's what they told me I'd be released today if they didn't get here by today. That's what the judge told me.
Yeah.
The judge told me that. We backdated it for Friday. Okay.
Okay, so I've never seen Judge Goodman do that, tell you you'll be released. I can watch the video, but if I watch the video and he didn't tell you that, I'm probably going to increase the purge. I don't know if I can do that since it's actually I can do that. I don't know if I would. So you're saying Judge Good. Let me make sure I understand, Mr. Cole. Listen to me. Look at me. You're saying Judge Goodman told you if they didn't pick you up by today, Friday, you would get out of jail. Is that what you're saying?
Yes, can I tell you the exact words he told the officer that's standing right here with me? He said that I want to backdate Mr. Cole's case for Friday, that if they don't come and get him by Friday, he's to be released.
All right.
That's the exact words that came out of the judge's mouth.
Corporal or sergeant, either of you have any notes that show what the judge actually said?
They wrote just a little circle thing on my paperwork for Friday.
I'm talking to them, Mr. Cole. Mr. Cole, I need you to be quiet. I'm talking to the officer now. Corporal or sergeant, do y'all have any notes that show what the judge said?
They wrote on the first appearance sheet, must be picked up by 12-5 per Goodman.
Okay, so let's watch the video. Give me a second and we'll try to find it. It wasn't labeled earlier like they normally are. So I couldn't find your video, but now that I see your physical appearance, I may be able to find you on the video quicker.
Judge, are you all right with me coming up there so I can hear it? My hearing.
You'll be able to hear it fine, but you can come up here if you wish. It's you'll be able to hear it fine once I find it. What date was that, Dawn?
It was November the 30th.
Sunday. So it had to be Holmes County because that's where all the first appearances were from. So let's see. Get to the part where they're doing Jackson County, maybe. That's not Mr. Cole. Still not Mr. Cole.
There he is.
They have them labeled now, thankfully. Okay, that makes it easier.
Go, when you're ready to write. Yes, Judge. And I did pull back case number
Is that the very end of the video?
order of contempt or right about. And I show that amount of 1,000. Mr. Green, go ahead.
But if you're able to first.
You said.
Hearing officer. But they would have to take. Yeah, because I'm not supposed to.
So for anybody who's just tuning in, what's happening right now is Wade Mercer is playing back a recording of a previous hearing in front of a different judge. This defendant is claiming that he was told if he wasn't picked up by another county by today, he would be released. So they're looking to see if that's really what happened.
How many cases?
While we're waiting, Ashley, thank you for gifting another membership. I'm really curious how this turns out. Put a 1 in the chat if you think this defendant's telling the truth. Put a 2 in the chat if you think he's lying. I'm really curious. 1 if he's telling the truth, 2 if he's lying, and let's find out who's right.
Have you seen the actual?
I'm showing the order. That's what I'm.
Okay, the chat is unanimous. Everybody thinks this guy's telling the truth. I kind of think he is too. I think somebody dropped the ball here, but let's see. Again, because I can tell some people have come into the stream. What's going on right now is Wade Mercer is listening back to a hearing that happened the other day in front of a different judge. And the defendant is claiming that if he wasn't picked up by today from, I believe it was Bay County, that he was promised he would be released. And he's holding true to that statement, and judge is reviewing the video of that hearing right now to see if that's what really happened. There was some notes apparently that indicated that probably was the case. It looks like right now he's trying to confirm. We are a little bit in the Wayback Machine here, and he just muted himself. So let me see if I can bump us forward a little bit. Wahoo says it still does not mean Judge Mercer has to follow it, is my understanding. Yeah, I think that'd be a little bit open to interpretation, too, if the judge said, like, if you're not picked up by Friday. What do you mean by Friday? Does that mean by the end of business Friday? Does it mean by the time Friday rolls around? There's certainly a lot of interpretation that can happen here, too. He keeps muting, but we are a couple of minutes behind, so... All right, let's do that. I will say this as he continues to work through it. Tell me in the chat another judge who would take this much time to figure this out. Maybe Middleton? But who would have the patience for this? Middleton's the first one that comes to mind. I know people that wouldn't. Boyd wouldn't. McNally wouldn't. Oakley most certainly would not.
Okay, I didn't know.
Okay. Ashley says Simpson would. Michael says Fleischer would. Yeah, I can't confirm on Fleischer anymore, though, because we can't see him. Who knows what he's changed into? Wouldn't it be interesting, though, if he started streaming again and he was like a completely different person?
Said is if Bay County doesn't.
Okay, here we go.
But we did finish the listening to the first appearance video, and what Judge Goodman said is if Bay County doesn't come get him by next Friday, he needs to be released. So what you're saying is essentially accurate. That's what Judge Goodman said. So my question is, Sergeant, what is your, you don't have a time frame from Bay. I think you already said that, correct?
Right. They've been notified, but I have not gotten a confirmed pickup date.
What time does day, well, the pickup date's today or it's going to be released. What time is the day shift in today at our jail?
Our
What time?
normal day shift ends at 6.
6 p.m.?
Yes, sir.
I thought y'all got off your administrative shift.
I
Maybe
get
you're saying the
off at
wrong
2.
thing. The
I get
administrative
off at
shift.
2.
Okay.
Administrative
You
shift
have-
is 2.
To have time to process him out, then if Bay County hasn't picked him up by 1:00 p.m., he can be released per Judge Goodman's order. So just call Bay County after first appearance, let them know that's what Judge Goodman did. And that's, you know, it may be Judge Goodman. I don't know whose case it is. It's not my case. It's a Bay County case, but we're going to follow what the judge told Mr. Cole and his family. Mr. McDaniel, anything?
Judge, Mr. Cole said they were going to come pay it, but they didn't want to pay it because he was going to get released today. But he also has another purge, another case that was not first appeared on, 11908 in Bay County.
Their feed froze up again. They're struggling.
Really bad out there.
All right, let's bump it a little bit forward.
Spitzer can do it remotely by Zoom or whatever. So, but if they haven't picked you up by what time did I say? 1:00? 1:00, you're gonna be released. They may have a hearing before then. If they have a hearing, obviously a judge or hearing officer can change that. I'm just trying to follow what Judge Goodman ordered. Any questions, Mr. Cole?
Yes. So basically, I won't get released today. What you're saying?
Mr. Cole, you heard what I just said. Just like with the
Yes.
last judge, you heard what he said. I'm very clear. There's no confusion. You will get out by 1:00 unless a judge orders otherwise. You understand that?
Okay. Yes, sir.
Have a good day.